Hi, everyone. Let's just give everyone just a minute to funnel in, and we'll get started here in just a moment. People are still joining, so we'll get started here in just a minute. All right, we'll go ahead and get started. This webinar is being recorded. Hi, everyone. Thank you for joining today's webinar presentation, Artificial Intelligence, Ethics Rules IP Practitioners should Consider. I'm Leah Wilhelm, Head of Demand Generation for North America here at LexisNexis Intellectual Property Solutions, and we have a really informative webinar planned for you today. But first, I would like to cover a few things before we get started. This webinar is being recorded, and you will receive a link to access it in a follow-up email. You can download the handout from the chat section. If you have questions during the presentation, please use the question section. And if you have any audio visual problems during the webinar, please let us know using that same question tool, and we will do our best to resolve those. We will answer as many questions as we can at the end, and once the webinar is over, you'll be prompted to complete a short survey where we welcome your feedback on this topic. This event is approved for 60 minutes of CLE credits. The type of credit requested is ethics. The type of credit allowed is determined by the state governing MCLE board, and attendees will need to validate participation using the 2 codes that will be provided during today's presentation. So be sure to write these down or take a screenshot of the slides. The codes will be provided both visually and verbally. So within 5 business days, you will receive an email from LexisNexis University that prompts you to log into your LNU account to validate your participation and to complete a brief survey with them as well. Once you validate your participation by entering those 2 participant codes, you will receive your certificate via email. So you always have the option to download a copy from your LNU account. If state approval is pending or needs to be processed, you will receive an email providing that status. Now I will turn it over to today's presenter, David Dillenschneider.
Thank you, Leah. And I'm going to go ahead and start this presentation with a question for you all. Who invented the manure spreader? Now, I know you weren't expecting that question at the start of this presentation, but I actually was curious about this question, so I posed it to an artificial intelligence platform, AI platform, just about a month ago. And you can see here that at least the AI component of Bing generated this result when I put in that prompt. And it let me know that Joseph Oppenheim invented the modern widespread manure spreader. And that's actually consistent with what Wikipedia says in its entry for Joseph Oppenheim. You'll see here that it says, quote, he invented the modern widespread manure spreader, unquote. In fact, here's Joseph Oppenheim's actual patent. And you can see that he filed the application on February 17th, 1900. And the patent was granted on May 1st, 1900, less than 3 months later. And he also founded the New Idea Spreader Company, which was headquartered in Coldwater, Ohio. It's about halfway between Dayton, Ohio, and Toledo, Ohio, a very small town. And this is actually a photograph of Joseph Oppenheim. All right, so I'm talking about this guy, Joseph Oppenheim. I'm showing you this photo. Why am I doing that? Because he looks just like me. And he should, because Joseph Oppenheim is my great-grandfather. And in my family, we take a lot of pride in the fact that our ancestor invented a machine that helps shovel, well, you know what. But anyway, let's go ahead and get started with this presentation. As Leah did, and I'm going to do as well, we want to kind of welcome you to this presentation about the ethics rules IP practitioners should be aware of when they're using AI. And in just a moment, I'm going to walk you through an agenda of what I'll be discussing, during the presentation. But, first, on a quick note, I just want to let you know I started out with that brief discussion about my great-grandfather, Joseph Oppenheim's patent for the modern widespread manure spreader, because I'm actually going to use that patent at several points during this presentation as I kind of go through these ethical rules. Quick introduction for you about me. My name is David Dillenschneider. I'm a client relations consultant for LexisNexis. I'm going to be your presenter till the top of the next hour. And I've been with LexisNexis for over 20 years now. Before that, I was a litigator with a large law firm for about 5 years. This firm was based in the Midwest. Now, as I just promised, here's the agenda. So first, I'm going to kind of just briefly define AI, and in particular, generative AI, which is obviously getting a lot of buzz right now. Then I'm going to get into a number of the potentially applicable ethics rules that practitioners, particularly IP practitioners as well, should be aware of when you're using AI. And as you can see on that list there, there's a lot of them. And I'm really going to highlight the one towards the bottom, 1.1. It's a very important rule for using tech these days. I'll then briefly mention a few additional consequences that may come into play, beyond just the violations of the ethics rules. Then I'll get into an in-depth discussion about the benefits and the risks of AI. And when I do that, I'll try to kind of keep you entertained with some, rip from the headline stories. And then lastly, I'll get into a bit about how there are IP platforms out there and how the companies that have developed them are really trying to maintain the benefits of AI, which I'll talk about, but also minimize the risks. Now, I know that sounds like a lot. It is. I am going to go to the top of the next hour. I have to because this is a CLE, but I guarantee you the time's going to fly by. And I hope that by the end, you've learned something new about these possibly applicable ethics rules, but also bag one of those coveted ethics credits. Now, as Leah mentioned, there's a handout for this presentation. It does not consist of all the slides because there's a lot of them. And as she mentioned, you can get the handout via the chat feature. But it's a nice summation of the key points of this discussion. Now, I also got to give you my disclaimer. Now, you don't have to read all this, but I just want you to understand that this presentation is not legal advice. It really just consists of my thoughts on what you, whether you're an outside counsel, whether you work as an in-house attorney, what you need to consider from an ethics standpoint when using AI in your practice. So basically, I just, I put this presentation together to be thought-provoking. That is it. I don't want to get an email from you 3 months from now saying, oh, you said this in your presentation, and I relied on it, X, Y, and Z. As much as I hate to say it in today's environment, kind of do your own research. And I actually have another disclaimer, and that is simply because the world of AI, as you well know, is changing pretty much daily. So I've added this additional language, and it basically notes that things are changing so rapidly that what I say today is based on my research that I was doing as of mid-February when I had to submit this presentation for approval. So things might have changed since then. And to reiterate what I just said, throughout this presentation, I'll be talking about, I'm going to show you results that I got when I ran searches on various AI platforms. Those searches were run in February, so just about a month ago. Now, there is one exception, a search I ran on ChatGPT last fall. I'll mention that. I'll call it out for you, but just a heads up about that. So the key is you got to stay on top of this topic yourself. In fact, if you're really into this topic, you may want to set up what we call at LexisNexis alerts, which kind of automatically notify you of new developments. Now, regarding the changing nature of AI, just a day or so before I submitted this presentation for approval, I discovered that Google had a new generative AI platform called Gemini, which replaced its old one called Bard. That's how quickly this stuff is changing. And then shortly after Google's release of Gemini, it was actually criticized for generating biased responses to certain queries. And in fact, a Google spokesman said, quote, Gemini may not always be reliable, especially when it comes to responding to some prompts about current events, political topics, or evolving news. This is something that we're constantly working on improving. Now, unquote. And that's a good thing, right? Constantly improving AI platforms. All right, so with that introduction, let's go ahead and move on. So several years ago, LexisNexis posed a question to legal practitioners at an ABA tech show. And it was a basic question about their biggest challenge. And you can see there on the left, the biggest challenge they noted was staying on top of tech. Now, that was several years ago. And with as fast as tech is moving these days, you probably too kind of feel that it's an ever increasing challenge. Now, when it comes to AI, I'm going to show you here on the screen just one of the probably hundreds of definitions that are out there, just because AI can be so broadly defined. But I think that the dictionary site Merriam-Webster put it pretty succinctly in its definition, and you don't see it here on the screen. That site says AI has been around since the mid-1950s and quote, and it is, quote, excuse me, the capability of computer systems or algorithms to imitate intelligent human behavior, unquote. And when you think about it, AI is all around us. We kind of know this. We interact with it every day, whether it's through recommendation engines like those used by like Netflix or Spotify, through like our voice activated digital assistants, even through kind of the automatic depositing of phishing emails into our spam folder, stuff like that. And in fact, legal tech companies like LexisNexis have been using aspects of AI. So when you think about that, think, machine learning, natural language processing, stuff like that, for over 30 years. And over the years, these companies have expanded their utilization of AI to improve your search experience, provide powerful analytics, give you efficiencies, things of that nature. Now, of course, as I mentioned, today the buzz is all about generative AI and how it creates something new. So it's not like a regurgitation, it's something new. And you see, I've highlighted novel and new on this slide. And that difference between AI and generative AI was echoed just even a couple months ago by the ABA itself. Now, importantly, AI, and especially generative AI, it really could be the missing piece in your practice. But you got to be aware of the ethical pitfalls, what I'll be talking about today. And some of you are concerned about this. In fact, according to a recent LexisNexis survey, 88% of practitioners have, quote, some concerns about the ethical implications of generative AI on the practice of law, unquote. And so if you got those concerns, it's your responsibility to learn as much as possible about AI and maintain that knowledge, again, as I mentioned, through things like alerts. So here's a list of several of the possibly applicable ethics rules you should consider when using AI. I'm going to go through each of these individually. And as I do so, you're going to see that I'm using the ABA's model rules, and that's simply because the vast majority of states' rules of professional responsibility or conduct, they mirror those of the ABA's. All right, so let's start off with 1.3. So how does this ethics rule relate to AI? Well, I know it kind of seems like a stretch, but at least according to a recent article in the ABA Law Practice magazine, quote, a lawyer's duty of competence and duty of diligence under Model Rule 1.3 arguably requires them to review and understand the terms of service and any data security representations of any AI technology, unquote. Now, I know it's extremely rare for us to be checking out the terms of service of the various research platforms we use, but just consider this 1.3 rule for what it's worth. Now, similarly on its face, you got Ethics Rule 1.4 addressing communications. It may not seem applicable, but I found a nice summation of its applicability in a Lexis Plus practice note authored by some attorneys from the HWG law firm. They wrote that Rule 1.4, quote, means that if AI is writing legal documents, a client must be told and given the opportunity to object. And it follows that when a lawyer plans to use AI, including document review or generation technology or other analysis tools, the client should be kept apprised of such plans, unquote. And I actually found another recent article from Bender's Immigration Bulletin, which says, citing 1.4, quote, although some clients may understandably resist the idea of artificial intelligence, lawyers should fully inform them of the risks and benefits, including lower fees and higher quality work product, of using AI so that they can make an informed decision about the use of AI and the representation, unquote. Now, Ethics Rule 1.6 and the related Rule 1.18, addressing confidentiality of relationships, is, at least in my mind, kind of setting off the alarm bells when it comes to the utilization of generative AI, because it addresses the inadvertent or unauthorized disclosure of client or prospective client information without that client or prospective client's consent. Now, you have the rule here on the screen, but comment 19 to that rule really adds some clarity in the context of generative AI, as it mentions the transmission of information relating to the representation of a client. And Chief Justice John Roberts recently added even more clarity, noting how legal scholars have raised concerns about inputting confidential client information into a generative AI platform, a prompt. Now, I kind of realized that the concern really isn't spelled out that well by Justice Roberts, but there was an opinion that came out of the Superior Court in Massachusetts last month that stated, quote, entering confidential client information into an AI system potentially violates an attorney's obligation to maintain client confidences because the information can become part of the AI system's database, then disclosed by the AI system when it responds to other users' inquiries, unquote. And in fact, this concern about disclosure of client confidences exists not just in the United States, but also elsewhere. For instance, you'll see here on the screen, the Bar Council of England and Wales said basically that if you input client information as part of a prompt into a generative AI platform, well, that platform thereafter uses that prompt to train itself to respond to future queries. And you are basically then, in effect, sharing that information with others. And such sharing of confidential information would potentially violate their core duty 6, which states, quote, you must keep the affairs of each client confidential, unquote. Well, how does Ethics Rule 2.1, you see here on the screen, relate to the utilization of AI? Well, look at the first sentence of the rule, how it mentions the exercising of independent professional judgment. Well, as you guys know, some generative AI platforms have become powerful enough to create legal documents, whether it's motions, briefs, patent applications, and the like. And the exercising of independent professional judgment means not just accepting a legal document created by AI, particularly generative AI. Yeah, from an efficiency standpoint, it's very tempting to accept that output from the platform, but the rule requires that you got to show independent judgment because, as you'll hear me discuss in a few moments, there are real issues with some AI results. Now, Rule 5.1 is one of the two supervisory ethics rules. 5.1 concerns a partner or supervising attorney who is overseeing or responsible for the work of another attorney. And Rule 5.3 relates to an attorney who's supervising or responsible for the work of a non-attorney. The critical language in these rules is found in C1. Basically, the supervising attorney is responsible for another attorney's or the non-attorney's conduct if, quote, the lawyer orders or with knowledge of the specific conduct ratifies the conduct involved, unquote. And even though it wasn't specifically referenced with respect to Michael Cohen's recent troubles regarding his submission of fake citations to his lawyer in conjunction with a request for an early end to his court supervision, his lawyer, Cohen's lawyers, likely violated 5.3 because he didn't double check Cohen's work. Because remember that Cohen was disbarred in 2018 and therefore is no longer an attorney, something he acknowledged in the sworn declaration you see here on the screen that he provided as an explanation as to what happened with respect to those fake citations he found when he searched Google Bard. Now, just so you know, it was a possibility of sanctions under Federal Rule of Civil Procedure 11, again, something I'll talk about in just a moment, that was raised by the judge. It wasn't 5.3. But these rules are just kind of the ones that I would say almost are on the periphery. The main guidepost for this presentation is the Rule of Professional Responsibility or Conduct 1.1, basically the competence rule. And I love this statement about AI that was made by a federal magistrate judge just a couple months ago about how AI is just another tool for bad lawyering. But existing ethics rules such as 1.1 may help address or actually prevent mistakes. All right, so 1.1 is actually fairly simple. You see it here on the screen. Quote, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Now, you're probably reading that and you're saying, okay, well, what does that have to do with AI? Well, the language of 1.1 is fleshed out in its commentaries, and of particular importance for today's practitioner is comment 8. Which states that a practitioner must be aware of, quote, the benefits and risks associated with relevant technology, unquote. Now, comment 8 to Rule 1.1 is still kind of relatively new. It was formally adopted by the ABA just about 12 years ago in 2012. Since its approval, it's actually been adopted by 40 states. and I suspect you're going to get a few more states following in the coming years. Now, to further this point, here's language from an article in the Oklahoma Bar Journal from just a few years back, kind of echoing this responsibility set forth in comment 8. And just so you know, this requirement in 1.1 is real. Commentators have noted this, and that's hopefully one of the reasons that you're attending this webinar. All right, so what does it mean for practical purposes for today's practitioner, you all? Well, in light of the recent pandemic, think of video conferencing technology, especially in the context of communications and confidentiality. You got to stay up to speed on that tech to ensure that you're compliant with 1.1. In fact, a somewhat recent real-life example of the application of 1.1 is from a lawsuit involving that media personality, Alex Jones. Now, as you may have heard, in the summer 2022, his attorney inadvertently disclosed the entire contents of Jones's cell phone to opposing counsel, who then used the information obtained to claim that Jones lied when testifying about a certain matter. And in an article concerning that incident, some attorneys wrote that, quote, most news sources believe that Jones's lawyer made a mistake of mind-boggling proportions, unquote. And then later in that same article, those authors posited that Jones's attorney's mistake was, as you see here on the screen, quote, a clear Rule 1.1 violation, unquote, based on comment 8. And by the way, you can't stick your head in the sand. You can't avoid the latest technology and later claim ignorance. As you see, this opinion notes, quote, deliberate ignorance of technology is inexcusable, unquote. And I mean, those are just a few examples. In fact, according to a recent law review article I read, courts have imposed duties of technological competence in a lot of areas. And this list is constantly expanding and actually now seems to include the use of AI. And as Rule 1.1 relates to AI, comment 8 means practitioners must be aware of its benefits and risks, which I'm going to get into here in just a few moments. And as noted in this article, I mean, it's not that using AI in and of itself is bad. Don't get me wrong. It's not understanding it, like its limitations, its risks. That's what can be problematic. And if you are a practitioner who's out there drafting patent applications, you are not off the hook when it comes to 1.1. According to this law firm, you too have to abide by that rule. All right, so those are the ethics rules that potentially relate to the usage of AI, but you also got to be aware that there may be more things to consider than just those ethics rules. For instance, the risk of being sanctioned for improper use of AI. Specifically, Federal Rule of Civil Procedure 11 sets forth the expectation that practitioners make reasonable inquiries and ensure that the representations made to a court are warranted by existing law. And just about 6 weeks ago, an attorney, based on research conducted via ChatGPT, cited a non-existent opinion in a reply brief that she filed with the Second Circuit, resulting in that court, the Second Circuit, referring her to a grievance panel for potential Rule 11 violation. And in yet another case, again, just from last month, a Massachusetts state court fined a plaintiff $2,000 for its attorney's inclusion of 3 fake citations to non-existent opinions, which had been generated by AI, in response to a motion to dismiss. Believe it or not, there may be other consequences. I mean, just last month, a pro se party had its appeal dismissed due to, among other things, quote, the submission of fictitious cases generated by artificial intelligence, unquote. Now, of course, the fact that there were 22 fake citations probably didn't help the party's case much. Now, as we get into this, I should mention that courts are concerned about these types of results created by AI platforms. And so they've started issuing rules, about using them. For instance, here's the new Circuit Rule 32.3 for the Fifth Circuit, which kind of seems to, dissuade practitioners from using generative AI, or if they're going to use generative AI, to kind of ensure that the results are reviewed for accuracy, not just accepting the results. But as you might think in your own minds, I mean, it's got to be recognized that actual compliance with these rules that the courts are issuing is kind of practically impossible, kind of simply because of the fact that AI is continually evolving. But nonetheless, it is a start. All right. So as Leah mentioned at the outset, during this presentation, I'm going to give you 2 codes. Here's the first code. I'll give you the second one right at the end of the presentation. She reminded you that you need to write this code down. You needed to get your CLE credits. I will give this code twice verbally, but it's also there on the screen for you to see. But again, write it down, please. So you have V as in vase, R as in radar, R as in rascal, the number 9, and again, the number 9. And I'll say that again. V vase, R radar, R rascal, the number 9, the number 9. That is your first code. I'm not allowed to repeat it. I'll give you the second code at the end of the presentation. But let's go ahead and dig a little bit deeper now. I want to get you to, this is really my efforts to help you comply with 1.1, that competency rule, which requires that you become knowledgeable about the benefits and risks associated with the technology you use in your practice. And as you can see here on the screen, there's, at least in my mind, 4 main benefits of using AI, particularly, even generative AI. Now, understand, this rule is not exhaustive. They're just kind of my thoughts about this. But to help discuss the first benefit, I'm going to break it into 2. And I'm going to start with vast amounts of data. Now, consider the number of patents that are enforced worldwide. According to WIPO's latest facts and figures at the end of 2022, there were 17.3 million. And that's an increase of 4.1% since the end of 2021. So obviously, that's a huge amount of data that a patent practitioner would have to sift through when doing his or her research, for instance, in order to draft a patent application, right? Well, now consider the first part of that benefit, management. According to a recent study or analysis done by Cipher, a practitioner can go through about 5 patents an hour. So according to my calculations, it would take about 3.5 million hours to go through all the patents enforced worldwide. Now, as I'll dig into deeply here in just a few minutes, an AI platform could go through that set of 17.3 million patents far quicker than a practitioner could. So long story short, there's a huge efficiency or benefit there. Now, the next benefit is availability. And honestly, this one's very simple. It's just that AI platforms, like other platforms out there, are truly available 24/7, except, maybe when they're doing maintenance or they're adding enhancements or things like that. For us all, that's a huge benefit, whether it comes to just the mere availability or whether it just concerns the ability of the platform to crunch a massive amount of data in a relatively short amount of time in order to assist us in our research. The next benefit, well, how about a reduction in human error? Now, when I think of this benefit, I'm thinking back to the imprecision I had in the Boolean searches I ran as a young associate many years ago. Now, if you've ever had to do a Boolean search to find, for instance, case opinions, this search would be woefully imprecise and potentially costly because, back then when I was in practice, some research platforms used to charge users by the search. I mean, think about it. Think of the possible synonyms for sidewalk that a judge might use, or for slip, or for house. The omission of any of those synonyms might cause you to miss an opinion that was critical to your research. Now, fortunately, legal research platforms have been searching for synonyms automatically for many years now, in an effort to kind of take that burden of finding all the variants off the shoulders of the researcher. And in addition, those legal research companies are using AI tech to tag documents, to classify them, indicating the relation to an issue or the like. Even if the particular facts are not identical word for word. And this can be more powerful than a human doing the tagging, simply because manual tagging by different individuals can be highly variable. Now, finally, unbiased analysis. Now, I think this quote that you see here on screen is kind of telling when it comes to this benefit. Because in essence, when humans are doing analyses, their conscious and unconscious biases can come into play. But when you bring AI to bear, that risk gets minimized as that processing can be performed objectively. But as you might suspect, we got to give that unbiased analysis benefit a bit of a caveat. And that's because the results created by a generative AI platform are only as unbiased as the data used to train that platform. So if the data, which is almost always created by humans, is corrupted by biases, well, then the results created by that platform are at risk of being similarly, kind of corrupted. All right, so now I've kind of articulated the main benefits of AI. It's now time to talk about the risks, of which I see three. Now, as I get into this, just a word of caution, be aware of these risks, but don't overreact to them. Not all these risks are always going to come into play every time, or maybe not even at all. Just be aware of them. Now, the first one is a big one, at least in my mind, and that's the quality of the data being tapped by or being used to train the AI platform in question. So just about a year ago, the Washington Post came out with an article addressing the data or content used to train ChatGPT. And you can see that the largest percentage of data comes from Google patents. So let me take you back to that patent my great-grandfather received in 1900 for the modern widespread manure spreader. Now, I've highlighted several parts of the original patent, including his name. You got the title up there, the specification, the intro language, quote, to whom it may concern, unquote, and even some of the language in the actual description. I've called out there, quote, manure distributors and spreaders, unquote. Now, here's Google Patents digitization of that patent. And as you can see, there are many errors in his name, in the title, et cetera. In fact, I've called out that descriptive language in the black box there towards the bottom. You'll see that, what should be the word distributors is misspelled with an N where the U should be. And that's important because if you go to Google Patents and type in the correct phrase from the original patent, you don't find anything. Obviously, because the word in that phrase, quote, distributors, unquote, is misspelled in the digitized corpus. The point is, if misdigitized patents are part of the tapped or the training data for an AI platform like ChatGPT, you might question whether that platform is going to be able to retrieve trustworthy or definitive results when you run a search on it. Now look at the fourth largest data set used to train ChatGPT, at least according to the Washington Post article, the New York Times. Well, as you probably know, late last year, the New York Times filed a lawsuit against ChatGPT and other AI platforms, not only seeking to enjoin those platforms from using content from the New York Times, but also asking for a destruction of all the training data used by the platforms that contain that content. Now, with that being said, there's a relatively new generative AI platform out there called Perplexity, which purports to allow a user to search only a specific corpus, meaning that a user could potentially avoid the pitfalls of misdigitization of certain content while tapping into better content, more reliable content, however you want to phrase it. In short, the issue or risk of poor training data might slowly be going away. And that's a good indication of how these AI platforms are constantly evolving over time, for the better. So it's a risk that's out there for some, but maybe it's starting to go away. Now, related to that risk, at least in my mind, is the second risk up here, open data sources being used by AI platforms, either to train them or just as information repositories. Now, I want to be specific about this. When I think of open data sources, and that's really my phrase, I think of data that can be put out there or manipulated by anyone. Not all data used by AI platforms comes from, supposedly reputable sources like the New York Times. Some of it comes from just scraping the internet. As suggested in this article, that could be a scary, proposition. And that's a point echoed in this article discussing how Google's Bard, which is now Gemini, has access to the internet. Now, I don't know exactly what that means, but I do know that the open web has a lot of garbage in it. Now, even more specific is this article, noting that the generative AI platforms like ChatGPT are trained in part using Wikipedia. And that's a point highlighted in that article from the Washington Post. In fact, according to that article, Wikipedia accounts for 3 times more data than the New York Times when it comes to training ChatGPT. Now, should that bother you? Well, here's the third slide I showed you today. It's a result from Bing regarding who invented the manure spreader. And note that a lot of the information about my great-grandfather came from Wikipedia. All right, so now I'm going to tell you a story. Here's a Wikipedia entry for the manure spreader. And note how it says that, quote, Joseph Oppenheim and Henry Sink are credited with the first successful mechanical manure spreader, unquote, down there at the bottom. And that's echoed in the Wikipedia entry for a man named Henry Sink. And you'll see here that he was the son-in-law of my great-grandfather. And, I mean, not only that, Sink's Wikipedia entry also says, quote, their invention, unquote, indicating that he was a co-inventor of the manure spreader with my great-grandfather. Now think about that for a second. I mentioned earlier that my great-grandfather was the inventor of the manure spreader. I didn't say co-inventor. All right, so what's up with this Wikipedia entry? Well, you can see right here towards the top that this is an old version of Sink's Wikipedia entry as of an edit on June 29th, 2008. Here's that current Wikipedia page for Joseph Oppenheim that I showed you earlier. I mean, it says that he, quote, invented the modern widespread manure spreader, unquote. But it even gets more specific, noting, quote, only he is honored for that invention, unquote. All right, so what's happening here? I mean, here's the current Wikipedia entry for Henry Sink. Now, the one I showed you just a few moments ago was an older version. There's a big difference here. It now says only that Sink worked with my great-grandfather to develop the manure spreader, and then specifically references, quote, Oppenheim's 1900 invention, unquote, and then later states quote, Joseph Oppenheim invented, unquote. So the inaccuracy in Sink's old Wikipedia page has been, I guess you'd say, corrected. Now, similarly, here's the current Wikipedia entry for the manure spreader. Again, note down there at the bottom, I apologize, it's a little small. It attributes the invention to my great-grandfather. In fact, check out the history of that Wikipedia entry for the manure spreader. The reference to Sink being the inventor of the manure spreader was removed by an editor because, quote, this statement is not documented, unquote. And it further notes that the USPTO shows that Oppenheim was the recipient of the patent for the manure spreader. Oh, by the way, who was the editor who made that change to the Wikipedia entry for the manure spreader? That would be my dad, John Joseph Dillenschneider, who made the edit this page on February 23rd, 2011. The point is this: had my dad not diligently edited the Wikipedia entries for the manure spreader, as well as those for Henry Sink and Joseph Oppenheim, those pages might still exist with their false information, allowing an AI platform to use them to create a false response to a user's prompt. So in my mind, it's a good thing that those entries got corrected. Remember, Wikipedia itself makes no claim as to the validity of its entries, and yet it's being used to train AI platforms. Now, the third risk, lag in time, is kind of an interesting one. The basic idea is that unless an AI platform is kind of accessing, getting its data in real time or in a timely manner, as opposed to accessing a previously created repository, the information created by that platform could be wrong due to basically it being out of date. Now, that's not something I realized on my own. This risk has actually been raised in various articles that I've come across over the months. For instance, note this comment from PC Mag about how ChatGPT, at least as of mid-2023, was trained on data that was gathered 2 years earlier. And although that point was specific to ChatGPT, according to this article authored by a law firm, many of the AI platforms suffer from the same problem. So as an example, I'll take you back to that number I showed you just a few moments ago. 17.3 million patents in force worldwide at the end of 2022, according to WIPO's latest facts and figures from 2023. Now, when I prompted Microsoft Bing with the question, quote, how many patents are in force worldwide, unquote, its chat AI component gave me the number 16.5 million as of 2021, based on WIPO's 2022 facts and figure report. And I kid you not, a few seconds later, I click on the Copilot feature of Microsoft Bing, and it gave me the number 15.9 million as of 2020, based on WIPO data. Now, let me emphasize just for a second what I just showed you. Two different results from Microsoft, depending whether I simply use the search tab or the Copilot tab. Now, I'm not a tech guy by any means, but at least that seems a little alarming to me. But anyway, I posed the same question seconds later to Google's Bard platform, and it gave me that 16.5 million result from 2021. So still dated, but at least consistent with what I retrieved via Bing's search tab. But what caught my eye in this result was that phrase, quote, most recent, unquote. that 16.5 million number was clearly not the most recent, because as I just showed you, there's a more recent White Bill Facts and Figure report that has a higher number. Now, Google's new replacement platform for Bard, Gemini, actually generated the same result about a week later. What about ChatGPT? Well, last fall, and I want to emphasize that last fall, I posed that same prompt to it, and it said 11 million based on its, quote, last knowledge update, unquote, in January 2022. But at least it cautioned that the number might have changed since then, kind of recognized a potential lag. But notably, when I ran that query again in ChatGPT just last month, after I ran those searches in Bing and Bard, that platform, ChatGPT, wouldn't even give me a number. I found that a bit curious because I'd come across this article from last fall, which indicated that ChatGPT was now able to provide real time information. So I just don't even know where we are with respect to ChatGPT when it comes to this lag in time issue. But again, maybe this isn't really an issue anymore, at least for some platforms, because they're making improvements, enhancements to get you more real-time data. But really just illustrates the evolving nature of AI, which again, as I mentioned earlier, makes it tough to do this presentation because what I tell you today may not be accurate tomorrow. All right, so think of those three risks I just walked you through. Their existence results in potential problems, many of them. For instance, differing results generated from differing platforms. In fact, I gave you an example of that in the context of the number of patents enforced worldwide, but I'm going to give you another. Okay, so once again, let's go back to one of those first slides I showed you today, the Bing search, naming Joseph Oppenheim as the inventor of the modern widespread manure spreader. Well, ChatGPT says Joseph Kemp invented the manure spreader in 1875. In fact, here's, I pulled out for you Joseph Kemp's advertisement for his manure spreader. There it is. But last fall, ChatGPT had Joseph Oppenheim as the inventor of the manure spreader. So again, I think this is a good sign that ChatGPT has updated the response that it gives for that prompt. But remember, the information that we're talking about here is over a century old. It's not like something new happened in the past few months with respect to determining who invented the manure spreader. What about Google Bard? Well, it actually kind of what I would call parsed its response, noting that the answer is, quote, a bit complicated, unquote. Recognizing that, whereas the first manure spreader was invented by Kemp in 1875, my great-grandfather invented the widespreading, also known as the modern, manure spreader later. And Bard's replacement, Gemini, pretty much echoed what I found in Bard, but added just a little bit more context there. Perplexity was even more definitive. Specifically, like Gemini, it noted the difference between Oppenheim's, quote, modern widespread manure spreader, unquote, and Kemp's predecessor. And if you click on the Wikipedia link provided in Perplexity's result, the article that it links to seems to provide a solid source for that conclusion. So, overall, I get some correct, but also some kind of more wishy-washy results from different platforms for an identical prompt. But then 3 weeks ago, it got really interesting. I was using ChatGPT and I ran the exact same prompt 3 times within 3 minutes. I kid you not, that's not an exaggeration. The first result had Kemp as the inventor of the manure spreader. The second result had Oppenheim. And the third result had Oppenheim as well. But notice that there's no use of those adjectives of, quote, modern widespread, unquote, in the Oppenheim references. So, all these entries merely said, quote, manure spreader, unquote. So it's a bit of an inaccuracy there, but even more concerning to me are the listed dates there. Look at them. In the Kemp entry, the date is 1875, which is consistent with the Wikipedia entry. But the first Oppenheim date is 1891, and the second Oppenheim date is 1897, and I got no idea where those dates came from. That's kind of the idea of the differing results problem. Now, the second problem is errors and hallucinations, and again, I'm going to actually divide that problem into 2, and I'll start with just, the pure errors. Now, obviously, I just went through differing results, the problem with that, which showcased errors, right? As well as probably some hallucinations, I think. But errors is a problem that the platforms recognize. For instance, Google confesses that, quote, Gemini can get things wrong, unquote, and later, quote, Never rely solely on content provided in Gemini responses without verification, unquote. So obviously, those are words that all of us need to really heed. Now, quick side note, the original version of this article was about Google Bard, and it was from December 8, 2023. That's the title you'll see down there at the bottom. It actually has been updated. It was updated on February 22nd, just about a month ago. But as far as I can tell, only the title of the article changed, and then throughout the article, Bard was replaced by Gemini. So for what it's worth. Now, the risk of errors was echoed in an article in the New York Times from just about a month ago, saying that results from Perplexity were, quote, mostly accurate, unquote. Hallucinations is the problem that's getting a lot of press recently, especially kind of in the legal world. And I think here's what is a pretty good definition of what a hallucination is. The key difference between an error and a hallucination is that an error seems to have a kind of a basis in some content it was trained on, whereas a hallucination kind of seems completely made up. Now, that's probably too simple, but there's got to be some overlap in there as well. But just still take these explanations as a grain of salt. But for a more concrete example, remember that it was Michael Cohen who provided fake citations, not wrong opinions, to his attorney. And those fake citations came from Google Bard. And a scary stat, at least for those tempted to use a generic non-legal research-specific AI platform, is that hallucination rates range from 69 to 88% for specific legal queries. And it really is a global problem. Here's language from an article out of Canada last month addressing an attorney's use of ChatGPT and its generation of citations to non-existent opinions. So fake citations, I guess you'd say. From an ethics standpoint, look at the language at the bottom. Quote, she was not aware that ChatGPT was unreliable, and she did not check to see if the cases actually existed, unquote. I hope, that language from 1.1 and comment 8 kind of are ringing in your ears, right? The benefits and risks associated with relevant technology. Now, sometimes you got to use common sense. Here's the slide I showed you earlier when I was talking about additional consequences of not being knowledgeable about using AI. Remember, the pro se party used 22 false citations presented to him. Now, I'm an experienced attorney, and I'm thinking that as I look at this, some of these case names would have really tipped me off that something was wrong. You got Smith versus ABC, you got Jones versus XYZ. The alarm bells are going off in my head. Now, the third problem is just plain what I call confusion. Now, what does that mean? Again, I'm going to take you back to a slide I showed you earlier. This one is the result given to me by Perplexity when I entered the prompt of, quote, who invented the manure spreader, unquote. And in particular, look how it says that Oppenheim was living in Canada at the time he invented the modern widespread manure spreader. But if we go back to another slide I showed you earlier, the Wikipedia entry about the manure spreader that Perplexity actually links to, it notes that Oppenheim lived in Ohio, and it was Kemp who lived in Canada. And not only that, but Perplexity has both Kemp and Oppenheim inventing their versions of the manure spreader in 1875. But as I showed you earlier, Kemp invented his in 1875, whereas Oppenheim got his patent in 1900. All right, one final example of confusion. Again, here's a previous slide. This is the fall 2023 result from ChatGPT, which shows Oppenheim getting his patent in 1875. Okay, so we know that's wrong. It's an error. But also remember that, again, ChatGPT now, at least as of last month, I think it has it right. But what's particularly weird, and I'll call it confusion, about this result from ChatGPT from last fall is that it says Oppenheim invented the manure spreader, quote, in the early 19th century, unquote. That's just weird confusion because 1875 is not the early 19th century. Okay, so that's my summary of benefits and risks, at least as I perceive them, when it comes to the AI platforms that are out there. Your takeaways, you can see here on the slide, stay on top of emerging tech. You got to avoid the blunders, but double check. And then there's roles for companies like mine, LexisNexis, to help you keep on top of this tech. So about a month ago, I was talking to Nigel Schweitzer, the CEO of Cipher, about generative AI. And he said to me words along the lines of, the challenge that we lawyers face is that there's too much choice and there's a lot of marketing hype. And you got these new vendors of legal and IP tech emerging almost every week, maybe a little bit of an exaggeration. And all of them are claiming, oh, our AI outperforms others, better, faster, cheaper, et cetera. And then he actually challenged me with the question. He said, what's the best approach when you're faced with this as an attorney? The answer is what you see here on the slide, right? Practitioners have to rely on trusted brands that have been around for years and really have the pulse of the legal consumer. Now, you may not appreciate it, but many of the patent-specific research platforms on the market today already employ a wide variety of AI, including machine learning, natural language processing, and other things. And these trusted brands, are actually starting now to dip their toes into incorporating generative AI into the platforms, either through their own development in-house or maybe through acquisition of best-of-breed startups. In fact, at LexisNexis, I know we're looking to incorporating generative AI to help our customers to kind of better understand and contextualize the data they get through our main patent research platform, PatentSite Plus. Basically to help provide more insights, better analytics, surface recommendations, things like that. But regardless of the approach, these companies, they have and they're going to continue to put that technology through the appropriate, what I would say, paces, basically to ensure that the benefits of AI that I just went through remain, while the risks that I talked about are kind of minimized or maybe, hopefully, outright eliminated. This is what I would call kind of the kicking of the tires. It enables these established companies to, avoid the experience we all have with the flashy startups that race to market with claims that really overpromise, but ultimately underdeliver. So on the screen, you'll see some of the companies that are offering AI in their IP platforms today. These are more established companies. Now, as you assess these and other patent-specific platforms, look for those benefits I mentioned, but with a minimization of the risks, as you see here on the graphic or the picture, kind of a threading of the needle, if you will. All right, so let's go back to those benefits and start with the vast amounts of data, even in the world of patents. Now, remember, as of the end of 2022, there were approximately 17.3 million patents in force worldwide. And by the way, worldwide is a real thing, as there are patents from not only the United States, but also large collections from countries like China, Canada, Japan, South Korea, and also, of course, from smaller countries. And if you poke around these various platforms, you can often get a good sense of the expansiveness of the patent data available from them. And of course, you'll see the companies making a lot of claims about their collections. So here's just some of the claims I pulled from the websites. Obviously, evaluate the claims carefully. For instance, at Notre Dame, that's where I went to school. At LexisNexis, we claim to have 100 million patent documents, not just patents themselves. And, companies are always adding to their collections. For instance, at LexisNexis this year, we're going to add patents from countries like, if you recognize the flags, India, Bolivia, Indonesia, the Philippines, Singapore, Thailand, Vietnam, etc. And by the way, if you're checking out a legal tech company's website and you come across a scary disclaimer like this one that says, not always available, some holes, be very wary. But remember, all the data I've been talking about has to be managed by these platforms. So remember this slide, the stat about a human can read 5 patents an hour? Well, check out this stat, how one of these patent platforms can process 61 million patents in an hour, which means for those 17 million patents in force worldwide, they can be processed in less than 20 minutes. And I love this marketing language from Cipher, quote, because life's too short to be counting and sorting patents manually, unquote. That's true. So if the platform you're evaluating can truly manage that vast amount of data, you've got that benefit covered. Same thing when it comes to availability. I mean, that's a no-brainer. The platforms don't sleep. We do, right? That makes perfect sense. So basically that benefit gets covered as well by these platforms. Reduction of human error. Well, AI often has the ability to take even in kind of an imprecise prompt and deliver accurate results because it's looking at, as I kind of mentioned earlier, not only for the synonyms based on the input data, but also ensuring that the corpus is properly, classified or tagged on the back end to enhance the ability of the researcher to find relevant information. So, like an imprecise prompt along the lines of, I want all patents related to X, that really suggests how critical a proper classification can be. And by adding enhancements on both what I call the front end and the back end, these platforms can cover the benefit of reduction of human error. The last benefit is unbiased analysis. And these platforms can achieve the benefit of unbiased analysis, not only through their use of AI, but also by tapping into closed data sets, ones that cannot be manipulated by outsiders to deliberately infuse bias. So for example, consider what PatentSite Plus is doing with respect to mapping patents to the UN's Sustainable Development Goals. As you guys know, patents are kind of fairly objective. Those SDGs, Sustainable Development Goals, are defined specifically by the UN. So as a result, the mappings, the classifications used by researchers, they're objective. So that fourth benefit, unbiased analysis, can be offered by these patent platforms. Now, what about the risks I mentioned a while back? Well, as noted by Dr. Christopher Wallach, the head of strategic IP management of Henkel Adhesive Technologies, you got to have clean data. It's critical. Think of the garbage in, garbage out trope. And remember to differentiate between marketing, the words you see here on the slide, from reality. But I mean, when it comes to reality, I can relate that LexisNexis, we take great pride in the fact that our data is rigorously cleaned, quality check it, we enrich it, as opposed to just the mere attempt at digitization of the documents. So for instance, remember the language from my great-grandfather's original patent? You see it here on the screen, and then I showed you the misdigitization of it by one of the patent platforms out there. Now compare that misdigitization with an accurate digitization by another platform. There's a big difference in the digitizations themselves. Now, of course, digitizations by any company are not going to be 100% perfect. They're digitizations. But the better they are, the more likely researchers will be able to retrieve relevant results. In fact, I'm going to go back to that misdigitization I just showed you, and I'm going to scroll down further through it to this language, and you'll see here roughly about 12 words between, quote, shown, unquote, and, quote, the distributing mechanism, unquote. Now compare that partial sentence to where it comes from in the language in the actual patent, where there are over 36 words between, quote, shown, unquote, and, quote, distributing mechanism, unquote. So, I mean, long story short, there are about 24 words completely missing from the misdigitization. And in fact, the phrase, quote, in a machine for distributing manure, unquote, is completely missing from the misdigitized version of the patent. So as a result of that missing text, the patent cannot be found when one searches that phrase in a platform that contains that misdigitization. I mean, you got results here from 1899, you got results from 1908, but nothing from 1900. All right, one final example of this, PatentSite shows 44,322 patent families when a researcher is searching for the owner, International Business Machines. But it also finds the same number of results for, IBM, for IBM with periods between the letters, for IBM with spaces between the letters. I mean, even for International Business Corporation or Intellectual Business Machines. But in a platform that doesn't say what I would call harmonize these very similar company names, a search of, quote, Intellectual Business Machines, unquote, yields only 28 results. And here's one of the patents I found titled, quote, a system and method for autonomic system management through modulation of network, unquote. And you can see the patent number there. I'll call it 2B2. Well, in PatentSite Plus, when a user searches for IBM patents, again, notice the specific use of the acronym IBM, and within the tens of thousands of IBM patents, only those that have that title, only one is found. Look at the bottom right there of the screen grab. And the one found is the one with the applicant name of Intellectual Business Machines. And it has that same patent number down there at the bottom, 2B2. So for these patent platforms that are taking steps to make corrections and harmonize the data in their limited repositories, that risk with respect to the quality of training data is minimized. Open data sources, well, I mean, it's been recognized that, quote, narrower domain-specific data sets, unquote, can improve both accuracy and relevance. And these patent-specific AI platforms are only tapping patents themselves or patent-related information, so no outsiders can really manipulate the data, as we saw from the general information from the open web or even specific sites like Wikipedia. Somewhat analogously, non-patent specific AI legal research platforms are actually doing the same thing. For instance, Lexis Plus strives to minimize hallucinations by, quote, leveraging trusted and authoritative content directly from LexisNexis, unquote. So by restricting their platforms to accessing only non-manipulable data sets, the risk posed by open data sources gets minimized. The last risk is lag in time, and many of these AI patent research platforms have taken pains to eliminate this risk by uploading the latest patents and patent-related documents to the respective repositories within hours of availability. And here's an example that I ran on Patent Site Plus just about a month ago on February 21st. And you'll notice that I restricted my search to all patents from February 19th to February 20th. And you can see on this screen that the most recent patent I retrieved was from February 19th. So like the other risks, there's a minimization of the concern about lag in time. And with the minimization of those risks comes the resulting minimization of the associated problems, particularly the ones of errors and hallucinations. Now, I know a lot of what I've showed you today can be, really, really scary, but AI is already out there. And generative AI is almost certainly going to be the future of patent researching. So as practitioners, you got to investigate, test, and then once you get comfortable, use a particular AI platform. As Nigel Schweitzer said to me, AI isn't going to replace attorneys, but an attorney who does not include AI as part of his or her tool set is going to be left behind. All right, so as I wrap up this presentation, just want to give you a quick reminder of what Leah said. Within 5 days, you're going to get that email from LexisNexis University. You'll have to enter the 2 participation codes I gave you, although I've only given you one. I'm going to give you the second one on the next slide. You're also going to get a survey in that email. Please complete that. Now, remember, if you don't get the email from LexisNexis University within 5 days, check your spam folder. So I'm going to give you your second code here in just a second, and then I'll say a thank you. And then right at the end, right before, as I close out, there will be another survey. It's only 4 questions. If you could just respond to it, it'll help us ensure that what we're providing to you in these CLEs is worthwhile for your work. Okay, as promised, here's your second code for CLE purposes. Again, write this down. I'm going to say it twice, but it's also up there on the screen. You have D for dog, F for fire, S for snake, the number 9, and again, the number 9. D dog, F fire, S snake, the number 9, the number 9. So there it is. You just knocked out an ethics credit. Hopefully also learned a little bit about the importance of being knowledgeable about the benefits and risks of AI when you're conducting your research. Thank you again for attending today. Remember, you can get a handout through the chat feature, and also remember to please complete the survey. Thank you again. Appreciate you attending today.
Thank you, everyone. Have a good day.